Mr. Attaran, your submissions.
Good morning, Justices. I'd like to add to what my colleague just said. The Athabasca Chipewyan First Nation is based in northern Canada. They have a traditional territory that stretches all the way from the west to Hudson's Bay, across several provinces. They've been there for over 7,000 years as a people, and their culture is really a golden braid of children born, of lives lived, and traditional knowledge learned in that place and across that vast time scale. It is their intimate knowledge of the environment that has helped them live for generations in what is otherwise a harsh, dangerous environment. It's their knowledge of hunting, fishing, and trapping that sustains them. And these survival practices explain how they made it 7,000 years. They're integral to their culture. They're existential in nature. And they're being changed along with the climate. In 1899, our culture agreed with their culture that these existential practices, these survival practices, were important, and we signed Treaty 8 guaranteeing their right to hunt and fish and trap. A century later, we amended our Constitution in 1982 to give those rights of hunting, fishing, trapping constitutional ennoblement and gravity. But now, as climate change is affecting our entire country, and the federal target is to limit it to 1.5 degrees, the ACFN face a very distinct challenge, because scientists from Environment Canada, this is in the record, have predicted that in their northern homeland of the Peace Athabasca Delta, in one lifetime, temperatures will not increase by 1.5 degrees, but up to 7 degrees. And a 7-degree change is monumental. To put it in context, it's comparable to the average annual temperature difference between Toronto and Sacramento, California. 7 degrees is the difference between Vancouver and Mexico City. That's the change that my client's looking at. It's climatologically the difference between home and being in a foreign territory. Those changes endanger their Aboriginal and treaty rights. For instance, woodland caribou is threatened, quote, threatened under the Species at Risk Act. It is illegal to hunt for that reason. Barren land caribou has been recommended for that listing, so it may very soon, too, be illegal to hunt. Yet, the ACFN call themselves Eten Delidene, which means caribou eaters. That hunt is integral to their identity and their culture and their being. And climate change, which is on the cusp of eradicating that ability to hunt caribou, or by making it illegal, by driving their numbers down, presents an existential problem of constitutional weight to them. And perhaps it presents a threat to their survival. Because, to be very frank, without hyperbole, if they can't live and practice the way they have for 7,000 years, if they end up in Edmonton, in the suburbs, that really is a kind of existential end for their culture. Now, these facts are hard, they're painful for the people involved, and with respect to the constitutional question, it's our belief, as my friend just said, that the 1982 Constitution is implicated by the Governor in Council's question. And it is, the facts I've just outlined to you bear on the constitutional question for several reasons. Number one, as the Supreme Court said in the Quebec veto reference, quote, the Constitution Act 1982 directly affects federal and provincial relationships, close quote. Unanimous Supreme Court. In the Quebec secession reference, quote, the individual elements of the Constitution are linked to the others and must be interpreted by reference to the structure of the Constitution as a whole, close quote. In other words, you must strive to read sections 91, 92, and 35 harmoniously to the extent you're able. I'm not saying that section 35 creates new heads of power, certainly not. What I'm saying is that it has to be read harmoniously with those other constitutional sections. And when you read it harmoniously, it militates strongly for the act being constitutional. Why? But for the act and a backstop, a province that fails to control GHG emissions effectively would further infringe or perhaps even extinguish the right of hunting caribou or fishing or other things under Treaty 8. To meet the Section 35 duty to my client, the Crown needs Parliament to set a backstop, and that legislation must be viewed with some curial deference for the Crown to be able to uphold the constitutional treaty right. Or to look at it in the converse, suppose that the court thought the act unconstitutional and it vanished. That in turn would lead to certain unregulated, unmitigated GHG emissions that could further infringe or very possibly outright extinguish Aboriginal rights when you hit a 7-degree warming and the homeland is rather like in a steamer basket, affecting the ecology in profound ways. That possible extinguishment of the rights of hunting, fishing, and so forth creates an obvious Section 35 constitutional problem. And it would mean that the Crown were violating those rights, which it can't do under the Constitution. I put it to you that to solve a Section 91 constitutional problem in a way that foreseeably accelerates a Section 35 constitutional problem has little to recommend it. It's not a fine solution. We agree with Justice Dixon in Mitchell and Peguis Band when he said, quote, "From the Aboriginal perspective, any federal provincial divisions that the Crown has imposed on itself are internal to itself." And so this is a case where you cannot look at watertight compartments. The only correct approach is one of double aspect, where both the province and the federal government are contributing toward GHG mitigations and the realization of the Aboriginal rights that are protected under the Constitution. With respect to POG, I want to say how the Crown-Zellerbach test and the anti-inflation test are somewhat affected by Section 35. I'm not saying overturned. Please don't hear me to say that. What I'm saying is that the Zellerbach and anti-inflation tests do need a little bit of a facelift to consider the place of Aboriginal rights. Anti-inflation speaks of a national emergency. Zellerbach speaks of a national concern, both of which beg the following question. Which nation? Which nation was the emergency or the concern? First Nations do possess, of course, distinct nationhood in our constitutional order. That's what Section 35 gives them. And so with respect to national emergency, I think you have to regard this. The anti-inflation case nowhere says an emergency must be pan-Canadian from sea to sea. You can have a local catastrophe that is a national emergency. An earthquake in Vancouver, a SARS outbreak in Toronto, local catastrophes but national emergencies. Turning up the thermostat 7 degrees on my client's homeland is a local catastrophe for them, but a national emergency. And that deserves consideration, particularly when it affects hunting and fishing. That means famine. Famine means a threat to survival. It's an emergency. With respect to Crown-Zellerbach, Crown-Zellerbach says that the court must consider, quote, an adverse effect on extra-provincial interests. An effect, I put it to you, on Aboriginal interests is inherently extra-provincial because of the discrete nationhood involved. And this brings me finally, if I may have 1 minute to do this, to the provincial inability test and consultation. Ontario posits that it can deal with GHG emissions on its own, but Ontario has failed to demonstrate in the record that it can do so in a manner that comports with Section 35. Why? If you recall the Made in Ontario climate plan, certainly it can affect Aboriginal rights profoundly, and therefore there must be, under Section 35, consultation and accommodation. Those are the requirements of Section 35 with Aboriginal peoples. What Ontario did, though, was simply to put that plan to a pro forma consultation online. They sought online comments, that's it, through which some Aboriginal information was gathered. That falls, an online website falls well short of the nation-to-nation meaningful dialogue that several courts of appeal in this country have said is necessary to fulfill the Section 35 duty. I put it to you that if Ontario's supposition of provincial ability in its Made in Ontario plan itself evinces a failure to respect Section 35 insofar as consultation and accommodation, quote, ability that rests on a constitutional violation is in fact inability. You can't found Ontario's constitutional right upon its constitutional wrong of not having consulted. Finally,
what do you say about the consultation of the federal government with respect to this act with your client and Native Aboriginal groups more broadly? Was there consultation?
Thank you for the question, Justice. We feel there was. We feel that it was respectful. There can always be more done, but no doubt the federal government made an effort in this regard, which is appreciated.
Thank you.
Thank you very much.